right. 50 years of Kesavananda Bharati case and its legacy. The seminal ruling in Kesavananda Bharati, in which the Supreme Court laid down the basic structure, doctrine on the limits of Parliament's power to amend the Constitution, recently completed 50 years. The Supreme Court's 13 judges bench in the Kesavananda Bharati case, 1973 articulated the doctrine of basic structure. According to this doctrine, the Parliament cannot use its amending power under Article 368 to destroy the basic structure of the Indian Constitution such as democracy, secularism, federalism, judicial independence, etc. The basic structure doctrine is a judicial principle that limits the power of the Parliament of India to amend the Constitution. The significance of this case. Established supremacy of the Constitution. It established the supremacy of the Constitution over the Parliament and the Executive and limited their power to amend the Constitution without affecting its basic features. Protected fundamental rights. It preserved the democratic and federal nature of the Constitution and protected the rights and freedoms of the citizens from arbitrary or authoritarian amendments. Judicial review. It asserted the judicial review power of the Supreme Court to examine the validity of any constitutional amendment and strike it down if it violated the basic structure doctrine. Primacy of fundamental rights over DPSPs. It resolved the conflict between the fundamental rights and the directive principles of state policy, and harmonized them by giving primacy to the former over the latter. Judiciary power to define basic structure. It paved the way for subsequent judgments that expanded and enriched the basic structure doctrine, such as the Minerva Mills case, 1980, which added secularism and judicial independence as basic features, and the Indira Gandhi case, 1975, which invalidated the 39th Amendment that sought to immunize the election of the Prime Minister from judicial scrutiny. Doctrine of basic structure. The Constitutional Bench in Kesavananda Bharati case ruled by a 7-6 verdict that Parliament could amend any part of the Constitution so long as it did not alter or amend the basic structure or essential features of the Constitution. However, the court did not define the term basic structure and only listed a few principles: federalism, secularism, democracy, as being its part. The basic structure doctrine has since been interpreted to include the supremacy of the Constitution, the rule of law, independence of the judiciary, doctrine of separation of powers, sovereign democratic republic, the parliamentary system of government, the principle of free and fair elections, welfare state, etc. An example of the application of basic structure is the S.R. Bommai case, 1994. In this case, the Supreme Court upheld the dismissal of BJP governments by the President following the demolition of the Babri Masjid, invoking a threat to secularism by these governments. Application of the doctrine in 50 years. Since 1973, the year of the Kesavananda Bharati judgment, the Constitution has been amended more than 60 times. In these 5 decades, the Supreme Court has tested constitutional amendments against the doctrine of basic structure in at least 16 cases. In 9 of these 16 cases, the Supreme Court has upheld constitutional amendments that had been challenged on grounds of violation of the basic structure doctrine. 6 of these cases relate to reservations, including the quota for other backward classes, OBC, and economically weaker section, EWS, and reservations in promotions. National Judicial Appointments Commission, NJAC. The Supreme Court has struck down a constitutional amendment entirely just once, the Constitution, 99th Amendment, Act, 2014. The Act established the National Judicial Appointments Commission, NJAC, the body that would have been responsible for the appointment and transfer of judges, replacing the current collegiate system. The amendment was struck down by a 5-judge constitution bench in 2015 on the grounds that it threatened judicial independence, which the court ruled was a basic feature of the Constitution. Partially struck down. In 6 instances since 1973, including the Kesavananda ruling itself, the Supreme Court has partially struck down a constitutional amendment. In all these cases, the provision that was struck down related to the denial of judicial review. Just one of these 6 rulings involve an amendment that was not made during the Indira Gandhi era, in Kyoto-Holoen, which dealt with the 10th schedule. Kyoto-Holoen vs. Sakalhu and others, 1992. The Supreme Court upheld the Constitution, 52nd Amendment, Act that introduced the 10th schedule or the so-called anti-defection law in the Constitution. The only portion of the amendment that was struck down was the one that stated that the decisions of the Speaker relating to disqualification cannot be judicially reviewed. In 2021, a 3-judge bench of the court struck down a portion of the Constitution, 97th Amendment, Act, 2011, but on procedural, not basic structure, grounds. The amendment changed the legal regime for cooperative societies.